has formulated its decision based upon the overriding principles and purposes of felony sentencing, which are to protect the public from future crime by the defendant or others, and to punish the offender using the minimum sanctions that the court determines accomplishes those purposes without imposing an unnecessary burden on state or local government resources. To achieve these purposes, the court has considered the need for incapacitation, deterrence, rehabilitation, and providing for restitution. The court has considered the relevant sentencing guidelines provided in 292911, 292912, 292913, as well as 292919. It's my understanding the parties have agreed that count 13 and count 14 shall merge for sentencing purposes, and that the state of Ohio is electing to go forward with count 14. Is that correct on behalf of the state?
That is correct, Your Honor.
Counsel, is that your understanding?
Yes, Your Honor.
As it relates to count 12 then, involuntary manslaughter in violation of 2903.04A, that will be a 3-year sentence at the Ohio State Reformatory for women. As to the 3-year gun specification, that 3-year gun specification must run prior to and consecutively with the underlying felony of the first degree. As to count 4, trafficking in cocaine, in violation of 2925.03A2 with the major drug offender, that'll be an 11-year sentence at the Ohio State Reformatory for women. The 1-year gun specification found in that count shall run consecutively to the underlying 11-year sentence. The gun specification in count 14 shall run consecutively to the gun specification found in count 12. Upon your release from the institution as it relates to count 14, you are subject to a mandatory period of post-release control. That's a mandatory minimum of 2 years up to a maximum of 5 years. That means that the adult parole authority, and not this court, will supervise you. They will give you terms and conditions you must follow. Should you fail to meet the terms and conditions of the adult parole authority, then they can modify and or extend your supervision and make it more restrictive, incarcerate you for up to 1/2 the original sentence imposed by the court. If you fail to appear for them, they can charge you with a new offense called escape, another felony where you face additional prison time, and if you commit new crimes while on post-release control, you can face the maximum penalty under the law for new crimes committed. Because this matter is subject to the Reagan Tokes Law, I'll note your lawyer's objection to a Reagan Tokes. I must advise you of the following. Pursuant to 2919B2C, there is a rebuttable presumption the defendant shall be released from service of the sentence at the expiration of their minimum term or presumptive early release date, whichever is earlier. The DRC may rebut presumption if, at a hearing held under 2967.271, DRC makes specified determinations regarding the offender's conduct while confined, the offender's threat to society, the offender's restricted housing, if any, while confined, and the offender's security classification. That if, as described in Division 2, DRC at the hearing makes a specified determination and rebuts the presumption, they may maintain the offender's incarceration after the expiration of that minimum term or after the presumptive earned early release date for the length of time DRC determines to be reasonable, subject to the limitations specified in Section 2967.271. That the Department may make the specified determinations and maintain the offender's incarceration under the provisions described in Division B2C1 and Division 2 of this section more than one time, subject to the limitation specified in Section 2967.271. That if the offender has not been released prior to the expiration of the offender's maximum prison term imposed as part of the sentence, the offender must be released upon the expiration of that term. As it relates to count 14, that would be an 11-year definite sentence up to an indefinite sentence of an additional 5.5 years or 16.5 years. I will waive the mandatory fine of $10,000. I will order the forfeiture of all items seized to the Cleveland Division of Police. As to count 15, having weapon under disability, that'll be a 3-year sentence at the Ohio State Reformatory for women. As to count 17, possession of criminal tools, that'll be a 12-month sentence at the Ohio State Reformatory for women. Counts 15 and 17 shall run concurrent to one another and shall run concurrently to count 12. The remaining counts, count 12 and count 14, shall run consecutive to one another. The court finds that a consecutive sentence is appropriate pursuant to Revised Code 292919B2B and 292914C4. The court finds it is necessary to punish the offender, protect the public from future crime, and is not disproportionate to the seriousness of the conduct and the danger posed by the defendant. That two or more offenses are part of one or more courses of conduct, and the harm caused is so great or unusual that a single prison term would not adequately reflect the seriousness of the conduct. Your sentence, therefore, is an 18-year sentence at the Ohio State Reformatory for women, up to a 23.5-year sentence. I will again waive any remaining fines, fees, or costs. I will grant you 385 days of jail time credit and any days awaiting transport. Counsel, does your client wish to appeal this?
Yes, Your Honor.
And does your client have funds to hire their own lawyer?
We would ask this court appoint for counsel at this time.
Ms. Grant, do you have money to hire your own lawyer?
No.
At this time, the court will find that you are indigent. I will assign the public defender's office to pursue an appeal on your behalf. I will order the transcript at state's expense. Is there anything else we need to do on the record on behalf of the state?